Intellectual property forms the backbone of the modern knowledge economy, contributing a remarkable £67 billion to the UK economy annually. This significant economic impact extends to employment, with 15% of all UK jobs directly linked to IP-intensive sectors. This presentation explores the critical frameworks protecting innovation in today's digital landscape. We'll examine the key IP categories, enforcement mechanisms, and strategic approaches organisations can leverage to safeguard their valuable intellectual assets in an increasingly competitive global marketplace. Intellectual property refers to the legal rights that protect creations of the mind. These intangible assets have become central to modern business value, often comprising the majority of a company's worth in knowledge-based economies. The UK's IP framework aligns closely with international standards while maintaining distinct national characteristics, particularly following Brexit-related adjustments to previously EU-harmonised practices. Understanding IP involves recognising its four primary categories: patents, trademarks, copyright, and design rights, each offering unique protection scopes and durations. The global counterfeiting market has reached a staggering £370 billion, threatening legitimate businesses and consumer safety across virtually every industry sector. The accelerating pace of digital transformation has created unprecedented IP challenges, from online piracy to complex cross-border enforcement issues. Approximately 70% of company value now resides in intangible assets, making IP protection a critical business imperative rather than a legal afterthought. Small and medium enterprises with protected IP rights generate 32% higher revenue than their counterparts without formal IP protection. Patents provide inventors with exclusive rights for up to 20 years in the UK, preventing others from making, using, or selling the protected invention without permission. In 2024, 17,635 applications were filed with the UK Intellectual Property Office, reflecting continued high levels of innovation activity despite economic challenges. The UK IPO conducts rigorous substantive examination, typically extending over 2 to 4 years before grant, ensuring standards for patentability and assessment of patentability are met. Effective patent strategy requires careful consideration of filing jurisdictions based on market significance, manufacturing locations, and competitor activity. Maintaining a portfolio incurs substantial costs through the 20-year term, necessitating regular value assessment. Strategic decisions include whether to create patent thickets or focus on core innovations only, balancing protection breadth against disclosure risks, particularly for innovations where trade secret protection might offer superior long-term value. Trademarks can protect various brand elements, including names, logos, colours, sounds, and even shapes that distinguish goods and services in the marketplace. Unlike other IP rights, trademark protection can last indefinitely through renewal 10-year registration periods. Post-Brexit, businesses must consider separate UK and EU trademark registrations, as the unified EU system no longer covers the UK market. This has created new strategic considerations for brand protection across European territories. Copyright protection in the UK arises automatically upon creation without any registration requirement. This provides creators with immediate protection against unauthorised copying, distribution, adaptation, and public display of their works. The protection extends to literary, dramatic, musical, and artistic creations. Digital rights management presents significant challenges in the online environment, where content can be easily copied and shared globally. The UK has developed specific exceptions for fair dealing and mining activities, particularly relevant for AI development and research. Design rights protect the appearance of products, including shape, configuration, pattern, and ornamentation. The UK introduced supplementary unregistered design rights to replace protection previously available under EU systems. This provides 3 years of protection for designs first disclosed in the UK, addressing a critical gap for industries like fashion, where rapid product cycles make registration unfeasible. Registered designs offer up to 25 years of protection, with renewal fees increasing over time. Unlike other IP rights, trade secrets can potentially last indefinitely as long as they remain confidential. This makes them particularly valuable for formulas, processes, and know-how that would otherwise eventually enter the public domain. The UK Trade Secrets Regulations 2018 provide a specific legal framework protecting confidential business information that has commercial value. This complements existing common law protection for confidential information, emphasising the most significant risk to confidential business information. Notable UK protected names include Scotch whisky, Welsh lamb, Stilton cheese, and Cornish pasties. These protections prevent producers outside the designated regions from using specific names, even with qualifiers like style or type. This system preserves traditional production methods while creating premium value for regional specialties. Following Brexit, the UK established its own GI scheme replacing the previous EU system, currently protecting 8 UK food names worth £7 billion annually to the economy. Beyond the primary IP rights, the UK recognises several specialised protections. The SUI Generous Database right protects collections of information from unauthorised extraction with 15 years of protection. Plant varieties and semiconductor topography also receive specific protection, ensuring originality and distinctiveness. Many businesses employ overlapping protection strategies, securing multiple IP rights for different aspects of the same product. For example, a smartphone might be simultaneously protected by patents, design rights, and copyright. Comprehensive review of intellectual assets, registered and unregistered, is crucial. Despite their value, 78% of UK businesses have never conducted a formal IP audit. Systematic evaluation of protection options against commercial objectives, considering factors like market size, competitive landscape, and enforcement risks, is essential. Identifying vulnerabilities in current IP portfolio and development of mitigation strategies for high-risk areas, including freedom to operate analysis, can significantly enhance business resilience. For startups and SMEs, intellectual property rights offer a significant growth advantage, despite limited funding available for protection. Strategic filing approaches include prioritizing core innovations, leveraging international filing deadlines to defer costs, and considering alternative protection strategies focused on primary markets. Common IP mistakes made by early-stage companies include premature public disclosure and failing to register trademarks before significant marketing investment. Addressing these issues can lead to a valuation boost and increased funding opportunities. The IP licensing market generates £13.8 billion annually across various sectors. Companies can leverage their intellectual assets through different licensing structures, including exclusive licenses, non-exclusive licenses, and sole license agreements. Key licensing terms typically involve clearly defined scope territories, fields of use, and royalty rates. Financial provisions cover upfront payments, royalties, minimum annual measures, and term considerations. Royalty rates vary significantly by industry, with pharmaceutical sectors averaging 9%, while consumer goods typically command 7%. Establishing clear IP ownership rules before collaboration begins is essential. The Lambert Toolkit for University Industry Partnerships provides standardized agreement templates, addressing background IP, foreground IP, and access rights. Developing fair mechanisms to evaluate each party's intellectual contribution to jointly developed innovations helps ensure balanced participation and compensation. Defining exploitation routes, territories, and revenue sharing for collaborative innovations enables all partners to benefit from shared developments, maintaining strategic flexibility for market entry. International IP protection involves navigating complex treaty systems and national filing requirements. The Paris Convention Priority Year allows applicants to file in other territories within 12 months while maintaining the original filing date, a critical advantage for securing rights where earlier filing dates prevail. Major patent offices, including the USPTO, JPO, and EPO, offer different examination standards and procedural requirements, necessitating strategic decisions based on regional market needs and enforcement capabilities. The UK offers a tiered IP enforcement system designed to accommodate different case complexities and values. The Specialist Intellectual Property Enterprise Court provides a more accessible forum than the High Court, with streamlined procedures and cost caps that benefit smaller businesses. Simplified procedure for straightforward copyright, trademark and unregistered design cases with claims under £10,000, often proceeding without legal representation, ensures efficient resolution of disputes. Her Majesty's Revenue and Customs seizes approximately 3.3 million counterfeit items annually at UK borders, representing only a fraction of infringing goods attempting to enter the market. clothing, accessories, and electronics are intercepted most frequently. Rights holders can file applications for action, AFA, with UK customs authorities, providing detailed information needed to identify potentially infringing goods. Major online marketplaces have implemented dedicated IP infringement reporting tools, allowing rights holders to request removal of listings for counterfeit products. Digital piracy costs the UK economy approximately £9 billion annually, affecting creative industries from film and music to software and publishing. Content recognition technologies enable automated identification of copyrighted material across platforms, facilitating more efficient enforcement at scale. AI-driven tools assist in monitoring online marketplaces to identify infringing listings based on visual recognition and pattern matching, offering new solutions for enforcement in the digital environment. The UK treats serious IP infringement as criminal offences carrying penalties of up to 10 years imprisonment and unlimited fines. The Police Intellectual Property Crime Unit, PIPCU, established in 2013, specialises in investigating and prosecuting organised IP crime, particularly focusing on online counterfeiting and digital piracy operations. Trading standards authorities hold significant powers to enforce IP rights at the local level, including authority and seizure powers, ensuring comprehensive enforcement across social media platforms. Alternative dispute resolution offers specialized methods for resolving international IP conflicts. WIPO's arbitration and mediation services provide expert technical solutions for cross-border patent disputes. The UK IPO offers a cost-effective mediation service with a high success rate in resolving disputes quickly. Nomet's Domain Dispute Resolution Service efficiently handles conflicts involving domain names, ensuring swift resolutions. Courts use various remedies and damages to address IP infringements. Injunctive relief prevents ongoing harm during proceedings, while Anton Pillar orders allow for evidence preservation. Financial remedies compensate for losses or profits due to infringement, with claimants choosing between mutually exclusive remedies. AI is driving emerging trends in intellectual property. UK patent applications for AI technologies have surged, reflecting increased investment. Legal questions around AI-generated works are evolving, with UK law requiring human authorship for copyright protection. Text and data mining provisions support AI system development while respecting copyright laws. The metaverse and NFTs present new challenges for IP rights. Virtual property rights frameworks must balance traditional IP systems with digital space characteristics. NFT licensing models require careful consideration to avoid misunderstandings. Virtual trademark infringement claims are rising, and jurisdictional complexity is increasing as digital spaces evolve. The future of UK IP protection is shaped by significant changes. The IPO aims for a comprehensive transformation by 2026. While Brexit introduces regulatory independence, major consultations are ongoing to address emerging technologies and international harmonisation. These initiatives aim to modernise the UK's IP infrastructure and create a robust system for the future.